What if your next business dispute doesn't end up in your local courthouse, but in a brand new Texas business court that hardly anyone's familiar with yet? That's exactly what's starting to happen across Texas right now. And if you're a business owner, investor, or entrepreneur, you need to know how this could affect your contracts, your disputes, and even your leverage in negotiations. For years, states like Delaware and New York have had specialized business courts, judges who focus on commercial disputes, corporate governance, and complex contracts. In 2023, Texas joined the club, and now the Texas Business Court has officially opened its doors. It's hearing cases and issuing opinions, and its expanded jurisdiction started September 1st, 2025. It's meant to create a faster, more predictable place to handle high-stakes business cases, and it has significant implications for litigants who meet the jurisdictional requirements and have their disputes in front of the court. Here's what's new in 2025. The Business Court can now hear cases involving shareholder or partnership disputes, fiduciary duty claims, breach of large commercial contracts, and trade secret or intellectual property cases. And here's the kicker. The amount and controversy threshold, the minimum value of a dispute needed to qualify, has dropped from $10 million to $5 million. That means a lot more cases are suddenly eligible. So if you're suing or being sued over a $6 million contract, a partnership breakup, or a trade secret claim, your case might end up in the new business court whether you planned it or not. And this isn't just a procedural detail, it affects strategy. Business court judges are appointed, not elected, and they focus exclusively on business law. That means more consistency, but also means less hometown familiarity. So for example, if you have a case in Travis County District Court right now, you could be on the rotating docket system, meaning you could have a different judge assigned for each hearing in the case. Often they are so busy that they're unable to read the materials in detail before the hearing. In contrast, if you're in business court, it's more like the federal court system in some ways. You have one judge handling your case, and they're appointed, not elected. They are most likely very familiar with your case file and very familiar with the type of legal issues at issue in your case. For plaintiffs, it can mean a faster, more sophisticated process. For defendants, it could mean facing judges who are laser focused on business conduct and fiduciary duties. If you have contracts, your forum selection clauses, the lines that say where disputes will be decided, may need to be updated. If you meet the amount and controversy floor, then you can agree ahead of time that any disputes related to the contract will be heard in the business court. And if you're drafting new deals, you might want to decide now whether you want to stay in the local district court or opt into the business court system. Here's what I tell my clients. Number one, review your contracts. Make sure your forum and arbitration clauses reflect your intent, not just boilerplate from 10 years ago. 2, audit your business relationships. If you've got investor or partner tension brewing, talk to counsel before it escalates. 3, plan for discovery and documentation. Business court judges will expect clean records and fast responses. You'll have to have all your ducks in a row ASAP if you find yourself in business court. These steps can make the difference between controlling the process or being controlled by it. I'm John McConnell, a Texas trial lawyer who helps entrepreneurs, investors, and business owners. If you own or invest in a Texas business, this is one of those moments where the legal landscape just shifted beneath your feet. Stay ahead of it. Don't wait to find out the hard way in court. If you found this helpful, hit subscribe, and I'll keep breaking down complex legal changes in plain English so you can stay one step ahead.